Welcome to this educational presentation by the American College of Legal Medicine and the American Board of Legal Medicine. This presentation deals with the history of pre-American legal medicine. I am Dr. Sanbar, a physician and an attorney. Early civilizations often intertwined their social precepts, religious doctrines, legal codes, and medicine. The ecclesiastical courts and canon law were concerned with religious matters as well as medicinal issues. Magic also played an important role in the medicine. Some of the so-called medicine men were sorcerers. They used charms and talismans, typically an inscribed ring or stone that is thought to bring good luck and have magic powers. Medicine men administered a vegetable drug or some remedy by mouth, which was accompanied by incantations, dancing, grimaces, and magical tricks. The relationship between law and medicine has been recorded for more than 5,000 years. Back in 3000 before Christ, the Chinese Materia Medica provided information about poisons including aconite, arsenic, and opium. In China, medicine herbs were discovered when the Chinese were collecting food. The earliest records of Chinese medicine are those of the ancient or legendary period, and they comprised largely mythology. They were full of concerning the founders of Chinese medicine. In 2700 BC, the Chinese Emperor Shennong was considered the father of medicine in China. He is still worshipped by native drug guilds as their patron god. He discovered Chinese tea when a tea leaf accidentally fell into his bowl of hot water. Shennong was credited with identifying hundreds of medical and poisonous herbs by personally testing their properties. That was crucial to the development of traditional Chinese medicine. But while doing research on herbs, to his misfortune, Shennong ingested a poisonous plant which caused rupture of his intestines and death. The Chinese have maintained that the human body has vital energy which circulates through channels called meridians. These meridians have branches connected to bodily organs and functions. The Chinese also believed in the presence of acupuncture points. In 1236 AD, a Chinese book entitled Washing Away of Wrongs was published by C. Lu. It outlined procedures to be followed in investigating suspicious deaths. The book stated that the medical examiner should make a thorough and systematic examination of every corpse, no matter what the condition was. The book advised the medical examiner about the problems associated with counterfeit wounds. It described wounds produced by blows from fists or kicking and deaths from strangulation or drowning. The book also distinguished between the bodies of drowned persons and those thrown into the water after death. It distinguished between ante and post-mortem burning. The medical examiner was cautioned that nothing in the inquest should be regarded as being unimportant. Between 1700 and 1100 before Christ, The Chinese made inscriptions on oracle bones describing the use of wine and hot water as medicine. They showed how needles and bronze knives were used as surgical instruments. Beginning in 2006 before Christ, the Han dynasty developed a highly sophisticated system of penal law in China which persisted through the Qing dynasty from 1644 until 1911 AD. The Chinese law was divided into official law and unofficial law. The official law was the rule and authority of the emperor. The law was divided into penal, ancient China law, and administrative law. The emperor was considered supreme and above the law. He could make new laws, change the existing laws, and could make any decisions. Well, let's turn to ancient Egyptian medicine. The ancient Egypt civilization lasted from 3,300 BC to 525 BC. Some of the earliest records of the medical care came from the ancient Egypt. Egyptian medicine dates back some 4,600 years, and the Egyptians believed then in prayer as a solution to health problems. But they also had natural or practical remedies such as herbs. The ancient Egyptians were probably the first people to have professional doctors who were respected. Imhotep was the vizier of Djoser in Egypt around 2600 before Christ. He was a healer, an architect, a high priest, and an advisor to King Djoser. As a healer, his medical writings rejected magic for dealing with illness. His premise was based on the theory that illness was caused by the environment rather than the gods. The Edwin Smith papyrus, which were the earliest known writings in medicine, were authored by Imhotep and others. Imhotep wrote about trepanation, trauma surgery, anatomy, cranial sutures, the external surface of the brain, cerebral spinal fluid, and about the diagnosis, treatment, and prognosis of some 48 medical problems. Additionally, the step pyramid in Saqqara, which was the oldest known pyramid, was designed by Imhotep. He was a master architect and authored an architectural encyclopedia which was used by his peers for millennia. The acts of the medical man were circumscribed by law. Egyptians believed that an angry god or evil spirit caused disease. However, they formulated a number of valid treatments and remedies. They differentiated various stab wounds and made different determinations regarding the cause of death and whether it was natural or not. Now let's turn to Semite tribes medicine. Around 4,000 years ago, nomadic Semite tribes used cuneiform hieroglyphic writing to memorialize their ideas and culture. They inscribed on clay tablets and then chiseled them into stone. The Semite tribes had developed a managed health care organization, and Hammurabi incorporated those managed care precepts. About 1700 before Christ, King Hammurabi of Babylon published the Codex Hammurabi on a huge stone, which is well preserved as the Babylonian Code of Law of ancient Mesopotamia. The Code is the oldest written law which includes legislation pertaining to the practice of medicine. The Code of Hammurabi covered the topic of medical malpractice and set out criminal liability for improper and negligent medical care. Penalties ranged from monetary compensation to cutting off the surgeon's hand. Fees were fixed. Judgments followed the traditional and harsh eye for an eye, tooth for a tooth punishments of the Semite tribes. But physicians merited public esteem. They were regarded highly and were adequately compensated. But they were also carefully prescribed and regulated by law. When they failed, the penalties were considerable. Now let's turn to ancient Greek law. Prior to the 7th century before Christ, the Greeks had no official laws or punishments. If someone were murdered, one of his or her family members had the right to kill the murderer back. That resulted in many bloody and endless fights. About 620 before Christ, the first law of ancient Greece was written by Draco. He was the first recorded democratic legislator of Athens. His task was to be a lawgiver for ancient Greece. He was the first legislator in a budding democracy appointed by the Athenian citizens. Draco's laws were very harsh. The English word draconian means unreasonable laws. Soon after Draco, Solon changed the laws, making it fairer to the Greek citizens. For example, if one stole something, the penalty would be decided by how much was stolen. Hippocrates was famous. He lived from 460 to 370 BC. He was an ancient Greek physician who was regarded as the father of medicine, who exercised a permanent influence on the development of medicine. He most famously said, "First, do no harm." He emphasized the ethics and law of medicine. The Hippocratic Oath states in part, "I will impart a knowledge of the art to my own sons and those of my teachers, and to the students bound by this contract, and having sworn this oath to the law of medicine, but to no others. Into whatever homes I go, I will enter them for the benefit of the sick, avoiding any voluntary act of impropriety or corruption, including the seduction of women or men, whether they are free men or slaves." Athens, in Greece, became the cradle of democracy. In ancient Greece, there was a knowledge of poisons and laws against abortions. However, autopsies were not performed, since a dead body was regarded as sacred. The legal code in ancient Greece, which was about 460 BC, was very elaborate. In addition, it was a time of great advances in medicine. Now let's turn to Roman law. In Rome, 600 years before Christ, a law was passed requiring that a woman who died in confinement should be immediately opened to save the child. The investigators of murder were selected from the citizenry. When Julius Caesar was assassinated in 44 BC, the physician Antistios examined his body and concluded that only one of the 23 stab wounds was mortal. The Justinian Code, which made its appearance in Rome between 529 and 564 after Christ, included within its provisions a precept that indicated that a medical expert would not be used to proper or greatest advantage if he were to be simply regarded as an ordinary witness. He would be appearing for one side or the other. The Justinian Code stated that the function of the medical expert was to assist the judiciary by impartial interpretation and opinion based on his or her specialized knowledge. Interesting anecdote is the arrest of Saint Januarius by Emperor Diocletian. For centuries, blood was collected from recently deceased holy persons, particularly martyrs for the faith, and the blood was carefully kept with devotion and veneration. During the 4th century, the Roman Emperor Diocletian persecuted innumerable Christians, including Saint Januarius, or Gennaro, the Bishop of Benevento. The bishop was imprisoned in 305 AD when he journeyed to Pozzuoli to offer encouragement to Sosius, who was a deacon who had been imprisoned. Later, the Januarius was decapitated and his body was taken to Benevento, then to Montevergine, and lastly to Naples, where it was entombed in the main church of the city with 2 vials of his blood that had been collected by devout followers. A great cathedral was constructed around his tomb. The priests would honor Saint Januarius by holding the vials of blood at certain times. Januarius' blood liquefied when it was used in 1389 after Christ. The saint's coagulated blood was noticed by the priest who was holding the vials to liquefy and bubble during a procession in the cathedral. The liquefaction of the blood of Saint Januarius was an extraordinary miracle of the Church, and it was repeated several times annually. However, the blood did not liquefy during outbreaks of disease, famine, war, or political suppression. Now let's turn to French law. France had an early start among European nations in the cultivation of a medical legal system. From 1570 to 1692, France enacted laws that, like those of Germany, favored the development of legal medicine as an academic discipline. By 1690, medical legal offices became corrupt, and progress in legal medicine actually regressed, not to start on a forward march again until after the French Revolution in the following century. Legal medicine is derived from French médecine légale and is considered the field of study and accumulation of materials that deal with the application of medical knowledge to the administration of justice. Forensic science is a broader term than legal medicine. The adjective forensic encompasses a group of subspecialties in science and medicine, all of which convey the fundamental concepts of methods, both scientifically valid and legally admissible for the presentation of evidence in courts of law. Now let's look at some interesting story. The impregnation of a woman by the devil or dream. During the period from 1620 to 1720 AD, a serious topic of conversation in both medical and medical legal circles was whether a woman could be impregnated by the devil or a dream. French judges legitimized an infant in a case in which the husband had been separated for 4 years from the mother on the grounds that the child owed its paternity to a dream. The picture is that of Popo Bawa, the name of an evil spirit or shitani, which is believed by the residents of Zanzibar to have first appeared on the Tanzanian island of Pemba. The highest medical legal authorities advocated belief in ghosts and witches and possession by the devil. They united with the clergy until 1752 in denouncing all disbelievers in these precepts as heretic and atheists. Until 1726, it was taught that in the presence of the murderer, his victims' wounds would open their congealed mouths and bleed afresh. Courts would accept the testimony of medical experts as to this miraculous bleeding of the corpse. Now let's turn to Dane law. American law dates back to Vikings' Dane law. The term Viking describes a person who sails away from his home to raid, trade, and explore. The Vikings were originally the Scandinavia people, presently Denmark, Sweden, and Norway. Scandinavian pirates and traders impacted greatly the history and culture of Northern Europe. Norman Danes, beginning in the 8th century AD, the Vikings terrorized continental Europe's coastline with raids. The Norwegians raided Scotland and founded Iceland. The Swedes raided the Baltic and Russia. Some of the Vikings were Danes from Denmark. The Proto-Norman Vikings settled their conquest and cultivated land. A group, the Normans, settled in the Normandy in northern France. A look at the Anglo-Saxon law in England. Before the Norman conquest of 1066 AD, disputes in local courts were settled by Anglo-Saxon law. but no standard or common rules were used. In 1066, the Normans invaded England and established the Dane law. The Norman kings considered themselves to be the head of the court. They viewed the justice system as a political power tool to increase their wealth and control. The courts were regarded as servants of some economic or social interest. Then came the common law in England. After the Norman invasion, common law was started in England by William the Conqueror. To gain control of the whole country, he set up the King's Court, Curia Regis, and appointed judges who traveled around the country to settle disputes brought to them by the nobility. The English judges decided cases based on local customs or old laws from the areas they visited, mainly based on Scandinavian, Danish law, and folk law. By 1250 AD, all the customs and laws were combined and developed to form a system of common law or case law in England. Turning to German law, in 1507 in Germany, a comprehensive penal code was established that called for proof of cause in all violent deaths. It allowed the opening of bodies and represented progress toward the practice of medical legal autopsies and the development of legal medicine as a separate professional discipline. It became a subject for special instruction in the 17th century, and by the start of the 18th century, it was designated, there were designated chairs in legal medicine who were created in universities. Around that time, the earliest applications of medical observations designed solely to aid justice were made. The hydrostatic test to see whether a child had been born alive was used in cases of suspected infanticide. In Germany, legal medicine was treated as being just a theoretical pursuit. It was eventually brought into the courtroom. For example, in 1667, Schwammerdam in Germany claimed that the lungs of a newborn baby would float in water if the baby had actually breathed. That is, if it was not stillborn and had lived and subsequently died, either by natural causes or by homicide. In 1681, Bernhard Gottlob Schreger, who was a German physician, used the hydrostatic test forensically and secured the acquittal of a girl who had been accused of murdering her illegitimate child. In 1553, the German Emperor Charles V published and proclaimed the Caroline Code, which clearly stated in its pertinent sections that expert medical testimony must be obtained for the guidance of the judges in cases of murder, wounding, poisoning, hanging, drowning, infanticide, and abortion, and in other circumstances involving injury to the person. Common law was made common to the whole country by Henry II. Its key features were the jury and courts of record, which were in place in the shire courts and royal courts. Common law was applied generally. It was not law designed to protect only ordinary persons without rank or title, that is, the commoners. In the 5th century AD, the Germanic and Slavic people took over Western Europe. They instituted a system of indemnity in lieu of the primitive system of personal vendetta. The person responsible for the inquiry would pay an amount to the injured party or, in the case of death, to the relative. The payment varied with the severity of the wound. The wounds in the code were classified. An expert testified as to the damages. The Visigothic and Bavarian codes noted injury to pregnant women, to the child in utero, poisoning of prisoners, and penalties of negligent doctors if the patient died. Let's turn to the Arabic and Persian canon of medicine. In 1025, the canon of medicine was completed by the Persian Muslim physician, philosopher Avicenna or Ibn Sina. It is an encyclopedia of medicine in 5 books written in Arabic and also called the Law of Medicine. It was translated at a later date into several languages, including English, French, and German. Avicenna was an extraordinarily gifted and prolific author of some 450 publications. He also described practical and scientific theories about psychology and mental illness. For centuries, the canon of medicine was exceedingly famous and influential. It was a medical authority. It set standards in the Middle East and Europe and served as the basis of traditional medicine. For example, when testing new medicine, Avicenna proposed the following: the medicine must be pure and contain nothing that would reduce its quality. The investigator must test the drug on one simple disease without complications. The medicine should be tested on at least 2 distinct diseases to determine efficacy and avoid accidental benefit. The quality of the medicine must match the severity of the disease. The investigator must time the process carefully so that the action of the medicine is not confused with other confounding factors such as the natural healing process. The effect of the medicine must be consistent with several trials showing that the same results are obtained, thus ruling out any accidental effects. The investigators must test the medicine on humans, not animals, and as it may work differently for both. Turning to civil law was based on Roman law codes. It was applied in Italy and in most of the other European countries that were originally occupied by the Romans. It is a codified system which spells out a series of written laws adopted by the jurisdiction. It is inquisitorial in nature and heavily dependent on the written word. Civil law judges are academics, specially trained for their positions, and act as prosecutors, judge, and jury. Common law, in contrast, is an adversarial system in which the oral argument between the parties plays a much larger role. It is largely judge-made law. It may incorporate some statutory elements of specific issues, but even statutes are subject to judicial interpretation. Judges are chosen from the practicing bar and are not usually academics. The judge is essentially a referee and instructs the jury. The jury makes the ultimate decision on the merits of the case. Or what is stare decisis? Common law is made by appellate judges who hear a disputed case on appeal. The decision by the appellate court becomes a binding precedent or stare decisis for future cases. However, higher appellate courts or future appellate courts of the same level can overturn or overrule a prior decision if circumstances change or new information develops. The cases were more or less confined to one of three categories: property law, contract law, and criminal law. Tort law, which compensates the individual for personal wrongs, lagged behind a little over that century. During the 13th century AD, doctors were essentially immune to suits for medical malpractice. But for the 14th century AD, that was historically disastrous to Europe. Black bubonic plague between 1346 and 1381 affected 50% of the population of Europe. 2/3 of the English population was wiped out by the epidemic. The loss of manpower was a major blow to the English economy. The people that survived the plague became as important as real property, land, and personal property like livestock. That was the English economy. A physician's mistake that deprived the economy of a worker became important enough to be brought before the courts as medical malpractice lawsuits. Physicians suddenly lost their immunity for practice errors. To permit the filing of civil cases, the courts resorted to two property terms which had been previously used in livestock cases. The first was trespass. That's trespass by force and arms, and that was charged for direct injury. And trespass on the case, which was charged for indirect injury. Consequently, civil cases against doctors were brought in royal courts and London city courts with alarming frequency, which is fully commensurate with the litigious present case in the United States. Many of the physicians' problems stemmed from the practice of physicians to undertake the cure of the patient and not to merely treat the patient. The medieval patient equated cure with fee. No cure, no fee. The early causes of medical malpractice in England in the 14th century against physicians were remarkably frequent for the following reasons: charging excessive fees, keeping the fee dispute a failure to cure, exacerbating the original complaint, medical neglect, and then maiming and death. By 1375, the concepts of fault and standards of care had been introduced, but the malpractice actions went on at an accelerated rate. In 1415, the London guilds established rules for mandatory consultations and a series of fines for not doing so. And in 1417, the Surgeons' Guild introduced a compulsory malpractice insurance pool. The high rate of malpractice suits continued well into the 17th century. Meantime, indigent migrants and criminals were being shipped to North America as indentured servants as early as 1650, and the rate of voluntary migration to North America increased steadily thereafter. They received freedom dues for their work. That's the indentured servants. In contrast, slaves were brought to North America and they were treated as property. They were auctioned, bought, and sold by their owners. Now let's turn briefly to the development of legal medicine in Europe. The development of legal medicine was always academically turbulent and against the intellectual current of the times. In 1209, Pope Innocent III provided for appointment of doctors to the courts for the determination of wounds. By 1720, professorships concerning legal medicine were founded by the state. About 1830, Germany established the first known medical legal clinic in Vienna, and a second one in Berlin in 1833. In 1794, in France, the first French professional chair in legal medicine was established. In 1840, France established its first medical legal clinic. In 1803, in Great Britain, the first British chair of forensic medicine was established at the University of Edinburgh. Around 1866, Charles the Great, Charlemagne, attempted to give some unity to the laws of the empire. There was recognition of the necessity of adducing all relevant evidence in judicial cases. There were articles discussing the direct intervention of physicians and instructions to the judges to seek all relevant medical evidence, especially in cases involving questions of wounds, infanticide, suicide, rape, and divorce and impotence. The first book on legal medicine was written in English by Samuel Farr in 1788 and was entitled Elements of Medical Jurisprudence. That was a succinct and compendious description of findings in the human body that were required for judgment by coroners and courts of law in cases of divorce, rape, and murder, among others. The first British teacher of legal medicine was Andrew Jackson, a professor of physiology who gave a course of lectures on legal medicine and public health beginning in 1789. His son, Andrew Duncan, Jr., became the first professor on the subject at the University of Edinburgh, where the first chair in legal medicine in the English-speaking world was established. Alfred Taylor, professor of medical jurisprudence at Guy's Hospital Medical School, wrote The Principles and Practice of Medical Jurisprudence. To fully prepare judges qualified in legal medicine, lectures were introduced in the law departments in 1892. In 1887, forensic science was largely a function of the medical profession and was most frequently referred to as medical jurisprudence or legal medicine. And finally, the British Association in Forensic Medicine was established in 1950, and later the British Academy of Forensic Sciences was created in 1960. Thank you.